going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day. I've got a good one. And it's not about the legal case. Now, this attorney is very angry with the entire court system, and he lets us know why. And I understand. I understand where he's coming from. Anyways, before I get into it, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
There's a pretrial conference today. Mr. Heflin and Mr. Williams are here in person.
I do want to say one thing before I start. Sorry, I should have made this part of my intro. I did turn the volume on this court up on my end. So if it's really loud, I think it's better for you to turn it down than you not to be able to hear it. Because the court volume is relatively low. So it might be a little too loud for you. I apologize, but I wanted to make sure that you could hear what was going on.
The plea offers to plead guilty to operating while intoxicating. The people would dismiss count 2, which is reckless driving. So, Mr. Heflin, is that what you intend to do or not?
Yes, Your Honor, I would like to address the court. We did not conduct a pretrial conference this morning, so let the record reflect that. I conducted this pretrial prior to court today. In fact, the prosecuting attorney who's assigned to this case is not at the pretrial. In fact, that occurs routinely in these pretrials, contrary to the process that the court has outlined. A prosecutor shows up, not the assigned attorney and not the attorney trying the case. So we did not conduct a pretrial this morning. In fact, I submitted a stipend order, which was signed by the prosecutor's office to set this for a plea. My client still needs a substance abuse evaluation. About a week or so ago, I went on record with you. I asked to order that transcript. I expressed to you again my frustration. I've been asking for an accommodation. I've heard the word come back from, I don't know if it was you, but I know Judge Cooney. I won't make an exception for you, Mr. Williams. I don't want an exception. I don't need an exception. I'm one of the best attorneys that this court deals with. Never need an exception, just want an accommodation. I have a medical history. I have a birth defect, I have a chronic disease, and I have chronic pain. Even as I talk to you right now, my face is twitching, it hurts. And I drove up here because you refused to sign a stip for me because of a policy where I'm asking for an accommodation. The court administrator here acts as the ADA coordinator. I explained to the court administrator, per your suggestion on the record, for an accommodation, for an ADA accommodation. The court administrator, who also sits as the ADA coordinator, clearly didn't understand my words or read the form because they sent that off to a law firm down in Lansing who billed this county for an opinion that had nothing to do with my request. So again, I'm making this record because I intend to see this through. I've been mistreated. I've been treated rudely, frankly, okay? I don't need an exception. I don't ever want to hear the word exception again come out of anyone's mouth towards me because I work hard. You know I work hard, and you know I'm ahead of my cases. And I simply could have had a form submitted and not drove up here today and spent several hours now driving, like I did earlier this week where I came up here for 3 other pretrials where you weren't available. I don't care, but you weren't available. And frankly, this process bills the county. Now you have court-appointed attorneys spending hour and a half, 2 hours here, wasting time billing the county when they could have spent 15 minutes on Zoom resolving this case. Talk to the other attorneys out there. We all pre-try our cases. We don't randomly show up to a pretrial date. Let's think about this process because this process needs to be known. Today, the prosecuting attorney's office walks from their office with a random attorney that walks into the courtroom, goes in the clerk's window and gets a stack of pretrials, probably 40 thick. That attorney only knows about what is in those forms related to that attorney's case only. So now that attorney will go into a pretrial room, look on their computer and see a recommendation from whoever is assigned to the case. Any attorney that's doing that, in my opinion, is committing malpractice that is showing up for the very first time, accepting a form, and then going back and telling their client, you better take this plea. In fact, I asked to have this set for a video conference hearing per the form. And that still was met with resistance. In fact, the court administrator told me when we spoke in her office that you guys could amend that form and that wouldn't even be an option. Again, I don't know what part nobody's hearing. This is cruel. It's rude. I have a birth defect. I have a disease and I'm in pain. And I simply could just resolve this with a form, which I've done for several years, hundreds of times. I've showed you my MRI. I've showed the court administrator my MRI. I've showed the court administrator who also acts as the ADA coordinator, which is a bizarre situation, my MRI. What do I need to do? Do I need to figure out how to sue this court in circuit court? Do I need to figure out how to sue this court in federal court? I've been in front of you for almost 20 years. You know me. I work super hard and I am super dialed in as an attorney and I do very well for my clients. The fact that I'm standing here is infuriating. It means that you guys don't care about my back. In fact, I had someone rude enough to say, oh, I saw Mr. Williams in the bike shop and went and told the circuit judges. And then that was brought up on record. Oh, well, here you're at the bike shop. Am I supposed to live like in a dark closet somewhere because I have a disease and not have any type of life? Am I supposed to like drive up here because of a personality problem? And that's what this is. It's a personality problem. It's not logically thinking. If someone, I can guarantee you, if a federal judge with some cognitive ability were to review this and said, hey, you guys really wouldn't allow this attorney to submit a form that has been doing this for years, that is never missed one, per your own staff said, my office in particular, and you were at that meeting, was ahead of everyone and always submitted the form and they never had a problem with me. What is going on? Seriously, what is going on? I'm laying on the floor at night. What part about that is anyone not getting? I go home, I gotta lay down on the ground because my face hurts, my back hurts, my legs hurt. I don't want surgery. I want to get through this. I've been in physical therapy now for on and off now for 14 months. I just got another MRI ordered last week. What gives? I mean, you have the discretion, but you know that opinion that this county wasted money on with that law firm, they cite an unpublished Sixth Circuit opinion that, well, let's waste some more money. But nonetheless, it says the court can give a accommodation. It doesn't have to give the specific one I'm asking for, but to give a accommodation. I could log in on pretrial days, Your Honor, and pre-try a case with the prosecutor. They could send me the form. They could submit the form. I don't understand this. It doesn't make any sense. Honestly, I hope that the county commissioners review this record and realize now with this policy in place, you have a two-pronged effect. You have one, it costs the county a lot more money because now attorneys are coming here, court-appointed attorneys, billing hourly for pre-trials that they already conducted. And I did speak to some of the attorneys this morning and they had conducted their pre-trials. So now the county's wasting money. And then two, it discriminates against poor people. And that issue, I think, is a bigger issue than my problem. Because what that does is that allows attorneys who are not looking at their cases, not looking at their discovery, and again, that was brought up at the meeting, and you know that there are certain attorneys that are doing that, and the prosecutor confirmed that at the meeting. They show up today, they walk into a room where an attorney is sitting, a prosecutor, they get handed a form, here's your offer. They never once spoke to the attorney assigned to the case. They never once even looked at their discovery, and they walk back out to a poor person who has no voice, no money to hire someone like myself, and they say, here's your offer, you better take it, you gotta take it, it's a good deal, and they never spend 1 second learning about that case. So this policy not only costs the county money, it discriminates against poor people, and I don't know what the heck's going on with me. I mean, I have a freaking disease, I'm in pain, I'm not doing well, I'm asking for some help, I'm asking for an accommodation. And what is going on? And I do think it's personal. I don't think Gwen Taylor likes me. She didn't like me. I'm going to say this record, and this will flush out.
I have to get moving.
All right. I'm trying to pause it as minimally as possible, but I do have to pause it. I'm sorry, guys. I completely understand where he's coming from. And, you know, I'm a big advocate of Zoom court. I've talked to judges and attorneys on my channel where I've asked them about Zoom court. They're all big advocates of it and for exactly what he's citing. And, you know, so he wants to appear by Zoom, and the court has made a decision that they're no longer allowing that unless there's exceptions. I think a medical reason is an exception, but I don't know what his medical issue is, and I'm glad I don't. I'm glad he doesn't actually say it because I just realized I didn't mute it out, so I was getting really close to the mute button when he was starting to talk about it. It's like, all right, but I'm glad he didn't say it. What do you guys think? Do you guys agree with him? Do you not agree with him? I mean, you can agree with him and not appreciate his approach. He's kind of yelling at the court right now, and he did go off on the court coordinator. And for those of you that don't know, the ADA is the American with Disabilities Act? Yeah, I think that's what he was citing. All right, let's keep going. And again, sorry for the longer pauses because I'm letting it play longer between pauses. The pauses are going to be a little longer, but it's easier to skip them.
I'm giving you a lot of time here.
It's good because I
State
want
your concern.
Right. So why didn't you sign my stip? It was signed by the prosecutor. Why didn't you, on the record, why didn't you sign my stip? You know all these problems I have. Why didn't you sign it?
I don't have to answer that.
But you do. Why didn't you?
I don't have to answer that, but you know the policy.
I don't want, what policy? What policy are you referring to?
We met a month ago at the courtroom.
Is that the policy where Judge Cooney?
So Judge Cooney told all the attorneys what his decision as chief judge and the administrative team have decided on.
Okay,
so that's.
So you're telling me because of a policy, you don't care about my medical problem? Is that what you're telling me? Because that's what I'm hearing.
I'm not saying that.
You have made comments about me, okay? Judge Cooney has yelled at me. If you want me to put this on the record, I will. I will. And I'm starting to think this is personal. When Taylor doesn't like me, one of your clerks that worked here told me very explicitly some comments that were made about me. Judge Cooney's told me to shut up on the record. And now I'm asking for a medical accommodation, which if anyone else other than the three of you who doesn't know me would look at this, look at my MRI and be like, well, what's the big deal? And now here I am again. You're telling me you won't. Are you autonomous? Are you a judge? You can make your own decision. You know what's going on with me.
So you're getting off track.
Why can't you help me with my situation?
Your issues, Mr. Williams, are not on the docket today. Okay.
What do you mean?
I've given you plenty of time.
We're here.
I have to move on.
So can you set this for a plea then for my client so we can get his substance abuse evaluation? As the form suggests, set for a plea. I turned it in, and I'll be back, and that'll avoid one more trip. But again, this doesn't rest here. So I'm going to order the transcript. You're telling me that you are not interested in my accommodation.
I'm not saying that. You can do whatever you want to do. And I've told you over the years how many times that I know you're a good attorney. You do a good job.
Why am I giving this? Why am I having this hard time? Why?
Well, all I can say, Jesse, is the chief judge has made a decision.
You don't have to follow
along with the administrative team.
You're the judge.
So anyway, Jesse, I'm sorry.
Judge just muted it. There's still a little bit more, but yeah. The judge muted it during this little period. It comes back on in about 10 seconds. And the judge leaves.
Oh, my question is, can this be set for a plea? My client's here.
All right. So he just got the judge to walk off the bench. He still has cases. He still has a docket. He had to take a breather, I guess. But this guy's not finished. You'll hear it. I'm gonna let it. There's still a bunch more to go. The video is only about halfway done. So, but I know I already asked this, but what do you guys think? Do you agree with him? Do you disagree with him? Do you agree and disagree? Like I do. Like I agree with what he's saying. Don't really love his approach, but I do agree with what he's saying. But again, I'm an advocate of Zoom court. But if you're not an advocate of Zoom court and you're going to say I don't agree with him for that reason, tell me why. Tell me why you don't like Zoom court. Because I've seen a lot of people leave a comment that says court should never be on Zoom; it should always be in person. I disagree with that, but I would, for a lot of the reasons this attorney actually just cited. But if you don't agree with Zoom court, let me know why.
You need Mr. Keller.
No, it's gonna be a video.
Okay. I need a break. That joint pre-roll that we had.
Yes.
Okay, that's all right. I mean, we have the final 13th of June, so I was planning on moving it.
Okay.
Obviously, we guys still gotta write motion stuff, so.
Right, yeah.
You think it'll be a couple more?
Yeah.
Okay, all right.
Yeah.
I'll just be.
Thank you. Can
Yeah,
I ask if we should just, I mean, I filled out my form, I asked except for plea, can we leave? I mean,
That's up to you.
well,
What
it's
you
my
do is up to
client.
you. I can't tell you what to do.
Well,
I mean, you're here now, the judge would be more than happy to take the plea.
that's fine. I would see if we can, do the sentencing then by Zoom if we could. We're gonna do the plea today. If we have the substance abuse evaluation, we'll move the sentencing. It's the first time.
If you want the judge to take the plea, I'm sure he would be willing to do that.
We'll talk more later.
Well, per the form, can they just set it now, per how the form says, because that's the box I checked. That's all I need to know. I don't understand.
You're here right now, so what you do is up to you. If you want the judge to take the plea, I will let him know. Otherwise, I gotta run these dockets out.
If you're wondering why she was just kind of short and snippy with him, yeah, that's his court coordinator, the person he just kind of threw under the bus. Not really threw under the bus, but yeah, he wasn't happy with her.
That doesn't help. Are we on the record still?
That's a strictly a guess.
Yeah. What do you think of that?
I thought it was a good argument.
If we do the plea today, there'll be one less thing we have to do, the final sentencing. They may very well approve it, make it shorter. But will you let them know that he will take a plea?
Certainly.
Thanks.
So People versus Patrick.
All right, and yeah, this is about 20 minutes later. I would say about 20 minutes later, the judge came back. Now he's going to take this guy's plea. Nothing really exciting about this, but at the very end, it comes back. He tries to get him to agree to let him come back by Zoom for the sentencing. There's still, I might have to pause it one more time. There's still about 8 minutes left of the video. All right, let's go.
Henry Heflin, file 24-1892 SD1. There's a pretrial conference today. The plea offer, Mr. Heflin, is you plead guilty to operating while intoxicated. First offense, a 93-day maximum misdemeanor with driver's license sanctions from the Secretary of State. Count 2, reckless driving, would be dismissed. So do you wish to accept that offer and plead guilty? All right. You're not on any probation or parole, right?
No, sir.
Other than this offer from the prosecutor, has anything else been promised to you, or have you been forced, threatened, coerced, or had anything done to you to make you plead guilty against your will?
No, sir.
All right. You've gone over all of your rights to trial then with Mr. Williams. Do you understand those trial rights?
Yes, sir.
Understand that by pleading guilty, you're giving up those rights. You won't have a trial.
Yes, sir.
You do understand the license sanction from the Secretary of State, is that right?
Yes.
All right. And if you could not afford Mr. Williams' services, the court would appoint a lawyer to represent you. Do you understand that?
Yes, sir.
All right. So the information here states on or about April 7 of this year, Grand Traverse County, US 31 North and Bunker Hill Road, you were operating a motor vehicle, is that right? Were you pulled over by the police, or did you have an accident?
Hold
All right. And when they had contact with you, they thought you might be intoxicated, so they ran you through a test there at the scene. After those, you were arrested and had a intoxilizer breath test at the jail, is that right? There were 2 readings there, .168 and a .166. Do you have any dispute with those results? All right, so I'll accept the plea. We'll dismiss count 2. All right, we're waiting for the assessment. So, okay, please accept the count 2 is dismissed. Let's see.
He's scheduled for an assessment on the 30th of
Right.
Friday. I'll have it most likely that following Monday. I can get it to the court. His prior history, I don't know if it's on there anymore. He had marijuana as a misdemeanor.
Okay.
Those, I believe, most of those have been removed from people's
All right.
records. So, and he did travel during bond out of country, no issues. I mean, he hasn't any issues. I would just simply ask if I could schedule a sentencing by Zoom. That's why I want.
And there we have it. All right, this is going to be the last pause. I'm going to let this video play out. What do you think the judge is going to say? The chief judge, what is it? Judge Cooney already made the ruling that, everyone has to appear in person, unless, they fill out the paperwork, and I guess his got denied. But now I'm just repeating myself. You guys all have a great day. Remember, let me know how you feel about what's going on here in the comments. If you haven't done it already, please like the video. I do work hard on these, and I would appreciate it. Yeah, until next time. Bye.
Adjourn this so I could have done the plea and sentencing. And it's just one, no, that's 2 trips. It just keeps adding up. And that's why I'm really frustrated, because I don't think anyone really cares. I think that there's a policy, and that's the only thing that anyone cares about. So.
All right, so we'll continue the bond. We'll set the matter for sentencing. I'll refer the case to probation for pre-sentence investigation, sentencing recommendation. We'll note that the substance use assessment's being done. You have to provide that to probation once it's completed.
Sure.
And again, bonds continued. Do we have a sentencing date?
Sentencing would be June 28th at 9:45.
Is that something that I could do on Zoom?
No, they're in person.
But you've approved it before. And if I would have set this by plea, you would have sentenced. And if I would have had a substance abuse evaluation, just like the case you just did before mine, you would have sentenced. And again, I will say it's personal, because you know these things, and you know this is causing difficulty for me, and you know I've been making this request, and there's no reason why you couldn't let me do it hundreds of times. I don't know why I can't do that. What date was that?
June 28th at 9:45.
All right, so we'll go on to the next case.
I have a bench trial that day in circuit court, so I can't do it by Zoom.
It's in person. The sentencings, are in person. There have been some exceptions that, yes, I've given you a chance to be there on Zoom, but
It's a first offense, not
that was
serious.
then.
It's a
So
first offense, not serious misdemeanor.
it's still a sentencing though.
But how many times have we proceeded to sentencing after plea, just like you did today?
So I'm just not going to debate this.
Can I just ask you this? Is anyone going to get back to me about my issue, or can I consider that you guys are just ignoring it at this point?
You'll have a decision from the administrator, I think, relatively soon. So
I was told that, like,
well, I can't do anything about it. Okay, I have to move on with my docket. So thank you.
Right.
Mr. Travis, then you have Mr. Hershey.
Yes, Your Honor.
What date are we doing sentencing?
What about that Monday, July 1st? That'd be 9:15.
Right. So this is file 24-106.